Good afternoon, everyone. This is Joe Corona. I'm a sales consultant covering the Northeast and the Ohio Valley here at Epic Retirement Plan Services, and I'll be your host for today's call. As you're hopefully well aware, the Department of Labor's Prohibited Transaction Exemption 2020-02 rules began to be fully enforced as of July 1st of this year. As such, we thought it would be timely to update you on how that enforcement is taking shape and what you can do to ensure that your processes, procedures, and documentation are tight. In a moment, I will hand the mic over to John Faustino of Broadridge to say a few words and introduce the star of today's show, Jason Roberts. Your line will be muted throughout the call, but if you have any questions you would like addressed at the end of the session, please enter them in the webinar control panel. With that, we will turn it over to John.
Thank you so much, Joe, and thank you to everyone who's giving us a bit of their time this afternoon to learn a little bit about PTE 2020-02 compliance. My name is John Faustino, and I'm the head of Broadridge FI360 Solutions. We were acquired by Broadridge. FI360 was about 2.5 years ago, almost 3 years ago. And recently, we've partnered with Jason Roberts, who is the CEO of the Pension Resource Institute and also the Retirement Law Group. And we worked with Jason to make modifications to an existing tool that FI360 had meant to facilitate compliance with IRA rollover regulations. When PTE 2020-02 came out, we saw unprecedented demand for tools and services to help folks with compliance there. And we've actually got over 100 enterprise clients in a relatively short amount of time on the revamped tool that Jason helped us build. He's a longtime friend of FI360. He speaks at our annual conference every year and is going to share some really good insights with you on the specifics of the regulation, what's required to comply. If after this webinar you have an interest in getting a better understanding on the tools and services that we make available, please let us know and we'll be happy to speak with you directly. And with that, I'm going to pass things over to Jason.
Thank you, John, and thank you, Epic, for having us today. I am not going to take a lot of time introducing myself, primarily because John already did, but because we have a very packed schedule today, we want to make sure there's time for questions. The one thing that I will say that I do think is very relevant here, at least about my background, is I am, I've heard some refer to it as a recovering litigator. So I started my legal career defending banks, broker-dealers, and investment advisors and their representatives from governmental agencies as well as their own customers. And that is really how then I've approached my entire legal career, whether it's the more proactive compliance solutions we deliver to those same institutions via Pension Resource Institute, or whether we're in a mode where we're representing plan sponsors at Retirement Law Group. I tend to envision what is that worst case scenario and how do we proactively put the pieces in place to avoid that worst case scenario. And a lot of times that is by enabling advisors, empowering advisors with various tools and resources to help their clients. Long story short, that is going to come through. That sort of jaded litigator perspective that we want to do what it takes to comply with the rule, and we don't want to go overboard. And you're going to see that as being a recurring theme, because it's always when you go above and beyond what is technically required that you risk sort of getting hung out to dry by your own policies, for lack of a better description. So I mentioned we have quite a bit to talk about today. We're going to just briefly recap the coverage and deadlines that ship has sailed, so to speak. So that should be not any sort of earth-shattering news for you. Then we're going to take a look at a very simplistic way to look at these retirement account rules. I have advisors and a lot of times home office personnel just saying this stuff is Greek to me. I don't understand it. And we try to boil it down actually into one slide that just speaks to the more of a common, plain English, common sense description of how this all works. We're We're going to briefly look at the covered account types. Again, this is something you probably already know, but in case you've left some out, we want to bring those to your attention. And then I'm going to take a step back for a minute and talk about what are the covered scenarios. The DOL defines the term rollover extraordinarily broad in broad terms. And it would include IRA to IRA transfers, for example. It would include a recommendation to take an IRA client out of a commission-based arrangement into a fee-based arrangement. And so I think it's important to understand not just the technical requirements, which we'll dig into, but kind of the practical, question of how much exposure is there here? When does this even come up? And then ultimately what is required? So we'll spend a little time on the practical side as well. We have to talk about violations and penalties. We don't have time to get into all of it. I'll verbalize that rather than take you through a more extensive set of slides. The biggest thing we're going to talk about at the end of the day, where the rubber meets the road, is investment advice versus investment education. And it seems like those terms should be self-explanatory, but I would submit they're anything but, and partly due to the fact that the investment advice, that phrase means a lot of different things to a lot of different people, even the DOL. So over the years, the DOL has defined that, pulled it back, reinterpreted it, and that's really where we are today, is with a much more expansive interpretation of that phrase that is capturing the activities of professionals that previously were not considered to be fiduciary in nature. We're going to close out with some action items. And I know there's a mix of what I would call more home office personnel that are navigating the firm compliance aspects of the rule. And then there are also quite a few of those of you that are on the front lines, actually interfacing with retirement investors, giving this kind of advice. So the action items are probably a little bit more geared towards the firm level response. So the PTE, just to level set, it only covers conflicts stemming from investment advice versus discretion. You can become a fiduciary under ERISA or the tax code by exercising discretion over retirement assets. And if your conflict arises out of that exercise of discretion, then this is an unavailable exemption to you. Now, the question I get a lot of times is, well, I'm an RIA and I have discretion over the IRAs that I manage for my clients. If I recommend a rollover into one of those managed IRA solutions, does that mean I can't use the exemption? And the answer is no. The conflict is arising based upon the recommendation. To the extent you don't have, and I don't know a single financial professional that does have discretion to take a client out of a plan and put them into an IRA without the client's consent, then that's the nature of that. So if you, for example, had private funds, or you were getting 12B on top of the advisory fee in the managed account, then those prohibited transactions would not be allowable under this exemption. It also, at the same time, covers a wide variety of payments that would otherwise violate the rules. And for example, just I'll pick one exemption that was issued in 1986, and it's PTE 86-128. They must have had a busy year in 1986, because 128 was the 128th exemption issued. And what it says is you can only receive quote unquote commissions that are earned in connection with the execution, settlement, or of a transaction, the clearing, execution, or settlement. That's not what this rule says. This rule says essentially you can receive any kind of conflicted compensation under the sun, but you need to comply with these conditions. And the conditions are procedural safeguards to make sure that that compensation is not excessive in amount or frequency. And so then the general conditions that we're going to talk about became effective February 1st. There was one small piece. It was an important piece, but in the grand scheme of everything that needed to be in place, it is just one out of probably 50 things that needed to be done that was delayed until July. And that is putting in writing the basis upon which the financial professional and the firm believes that the recommendation to roll over is in the retirement investor's best interest. So again, it's a big one, but it's only one out of many. Everything else should have been in place by February 1st. If it wasn't, you will be looking at some self-corrections over the course of the next year, and that is something what you want to take very, very seriously, because again, the DOL didn't do us any favors there. It's muddy at best in terms of what is required to truly self-correct. So it leaves a lot up to interpretation. We're encouraging firms to err on the side of being conservative, but definitely seek out experienced counsel if you are starting a self-correction process. So I mentioned to you a very plain English description of what we just generally call retirement account rules. And there's really three things at issue. Number one is, as a fiduciary, you're held to the highest standard of care. Particularly an ERISA fiduciary, you're held to deliver prudent advice that's solely in the interest of the client. So if you have a financial conflict, you are unable to meet that solely in the interest standard. So that's the middle here. So we're held to this fiduciary standard. We have to give loyal, prudent advice. If we have a conflict in the form of increased fees, commissions based on number of transactions or frequency, 12B1 trail, solicitor fees even, then we have a conflict. And what the rules say is you cannot get paid unless you comply with the conditions of an exemption, because that fiduciary standard coupled with the conflict means you have a prohibited transaction. And prohibited transactions, as we'll look at here in a minute, they're per se liability, so to speak. Doesn't matter how well-intentioned you might have been, or even how great of an outcome to a degree that you achieved for that retirement investor. If you did X and you didn't satisfy the conditions, then at a minimum, you're required to disgorge your fees, you're required to pay interest, and then to the extent there are any investment losses, you would need to restore them. So you're basically trying to put the client in a place they would have been but for the violation that you intentionally or unintentionally engaged in. And so that's it. That's the plain and simple way. The tax code defines prohibited transactions almost verbatim as ERISA, at least when it comes to fiduciaries. And you can't give fiduciary advice that is financially conflicted and get paid without complying with an exemption. So these are the actual three, and this is sort of paraphrasing again, trying to bring it back to plain English, but you can't self-deal, you can't represent a buyer and a seller or two parties who have an interest in the transaction involving plan or IRA assets at the same time, and you can't give fiduciary advice or exercise discretion in exchange for receiving compensation from a third party. Well, for those that are registered representatives on this call of a broker-dealer, you know the entire compensation model is third-party payments. Hence, the challenges of broker-dealers face not only at the conflicts of interest regulation, while that was effective, but also in preparing for complying with PTE 2002. It's just the nature of that model that you're going to get paid by the product sponsor, asset manager, even in some cases through the arrangements with your clearing and custodial partner. So there are exemptions that apply. They're available to all stripes of financial professionals, but these are the three prohibited transactions that are imposed on fiduciaries to either ERISA plans or IRAs. Real brief example of self-dealing, and this is going to carry through the rest of the deck, is we work with a lot of fee-only RIAs, and they'll say something like, I don't have any conflicts. That's why I became fee-only. And I'll give the simple example of a prospective client walks into your office. They have a terrible 401k plan. They're bringing their statements, their fee disclosure, and you can see that it's overpriced, underserviced, poorly performing investments. And it's just not anywhere you'd want to see one of your clients investing. You propose to them a very reasonable fee for ultra high touch white glove services. You're going to meet with them 4 times a year minimum. You're going to manage their account. You're going to sweep in financial planning, retirement income planning, all of these other bells and whistles, and they're going to get a ton more value from your services than they're getting in that terrible plan. You make the recommendation to roll over. You've just engaged in a prohibited transaction because you went from earning nothing on those assets to whatever that reasonable fee is that you're proposing. So it's very benign activity, can subject you to having to comply with these rules. These are all of the different affected account types. You know, the ones that might be a little bit of a sleeper are HSAs, medical savings accounts, education savings accounts, but for all intents and purposes, they're treated like IRAs for purposes of these rules. One thing to note here is that we get a question fairly frequently that, well, what if it's a non-ERISA 403B plan? And I'm recommending a rollover into an advisory IRA. Well, you'll see here in a minute the way they have reinterpreted the phrase investment advice based on that fact pattern that I very carefully articulated, advisory IRA, and I am making the recommendation. Sure, you don't have the ERISA coverage component of the 403B plan, but you will have the IRA coverage component, and the very first piece of advice you're giving to the IRA, rollover IRA client is to liquidate their employer plan account. And so, hence again, you still have that conflict, that financial conflict, and therefore a prohibited transaction, and you would need to follow the conditions of the exemption. So this is something I want you just to take in for a minute here, and I'll spare you the nonstop talking while you do that, and just have a sip here. Because what I want you to think about is, first of all, this bottom right quadrant is orange for a reason. That is the most scrutinized transaction that's at issue here in this rule. The upper right one is green for a reason. And that is because it's only applicable if there are a number of conditions that are satisfied. And I'm not talking about exemption conditions. I'm talking about conditions precedent to giving the advice and so forth. And what I mean by that is, A, if you're going to be subject to this rule and having engaged in a prohibited transaction, you would have to be the advisor of record, your firm, on the plan receiving the rollover into that plan. And you would have to be receiving asset-based compensation such that recommending that rollover, you have a financial conflict in that you're getting an asset, lifted asset-based fees. Not only that, but you would also have to have a pre or post advice relationship with the individual concerning his or her tax advantage accounts. So there's a lot of ifs there. And for that reason, this is a less often used scenario when it comes to, how concerned am I on a scale of 1 to 10 about this upper right quadrant? Probably more of a 2, whereas the bottom right is a 10 out of 10. The left-hand side, as you'll see in a few slides, is also different in number 1, assuming no ERISA plans are involved, DOL doesn't have they don't have enforcement jurisdiction. They can still investigate, they can still refer to IRS for enforcement, but DOL can't in and of themselves enforce these. That's not a reason to necessarily take your foot off the gas or treat these other rights differently, but there are some definite reasons you could treat these differently. For example, you're not required to gather as much information as you would in either of the right-hand scenarios for these on the left-hand. The last thing I'll say here is, two quick points. One is if you are fee only or you're recommending a fee-based arrangement, let's say you're a bank trust officer or investment officer for a trust company or an investment advisor representative, and the only thing you have to offer is fee-based. If you're recommending a client move out of a commission-based arrangement, then it's inherently it's covered by this rule. You need to comply with the exemption. The IRA to IRA, the thing that I always point out here, a lot of this could just be marketing. You might just be earning the business of a prospective client who has multiple accounts that they're going to bring over once you've convinced them that your services are what they're looking for. You notice I emphasize services because, as you'll see in a minute, you're free to market your services without it being considered quote unquote investment advice. So different sort of risk spectrum in our PRI member firms and our law firm clients who are treating these differently are finding better success, more efficiencies, less confusion among their representatives. And so I just wanted to point that out. What I'll say here just briefly about violations and penalties, I already mentioned it to a degree. DOL is going to investigate financial institutions for compliance with this rule. And they have clear enforcement authority. For example, if you're recommending a rollover out of an ERISA covered plan like a 401k into an IRA. The reason being is the first part of that two-part act is the liquidation of ERISA plan assets. They have clear jurisdiction there. But you can see they say, well, for IRAs and other non-ERISA plans, we have this interpretive authority, which we believe allows us to transmit information to IRS so that they can impose excise taxes. So I'm sure a lot of you are thinking, I've never seen the IRS in my office asking to examine my books and records for compliance with the Internal Revenue Code prohibited transactions. And that's true. They don't have a dedicated division doing that. But when served a violation on a silver platter, you can bet that they're going to levy the excise taxes and collect those taxes. Also, there's a lot of our member firms and law clients will ask, hey, we had this one example where we just technically didn't satisfy a particular aspect, but everything else worked out great. And I always want to point you back to where the DOL said they don't believe that there's anything minor or technical when it comes to violating one of their conditions. So again, this all goes back to self-correction. How do you, once you've discovered a deficiency or a violation, what do you do about it? And again, that should, in fact, I did give a webinar about 2 weeks ago where that was the entire focus. So we obviously don't have time for that today. Investment advice, as I mentioned, means a lot of different things to a lot of different people. And the DOL says it means from 1975 onward that it means you're giving advice concerning securities or property, the advisability of investing in those securities or property. You're doing that on a regular basis. It's pursuant to an understanding that it will serve as a primary basis of that investor's investment decisions and that it's individualized. A lot of these are throwaways. What regulator allows you to give advice that's not individualized to the needs of that client? All RIAs and bank trusts or trust companies are going to give advice on a regular basis or even have discretion. So those are really throwaways, and only the broker-dealers and insurance agents are able to, in some cases, say we recommended a product or a transaction, but it doesn't satisfy the test because there's no regular basis component to it. And even those companies now, they're really starting to, given the temperature with the DOL these days, they're starting to embrace the fiduciary status where they might not have to, just to avoid violating a condition and not having the procedural safeguards in place. This is the biggest twist in everything that happened with the DOL in publishing this rule. What it said is it now interprets investment advice and the regular basis requirement to be inclusive of having a pre-existing relationship. We might have said before I was advising this person on their 401k account. And when I then advise them on a rollover, that's a different type of transaction. It's not regular basis advice concerning the investment of that particular account. And so therefore there's a difference. And the DOL says essentially no way. That if you have a pre-existing relationship that's advice in nature, you're satisfying the 5-part test. In other words, recommending the rollover will be viewed as an extension of that fiduciary advice. And to the extent you're able to increase your compensation or affect third-party payments, you have a prohibited transaction. The bigger change in their policy and the new interpretation is they said, even if you don't have a pre-existing relationship that's advice in nature, if you're going to have one once the assets are rolled over, we're going to view the first piece of fiduciary advice that you gave as that recommendation to roll over. And as I mentioned in my hypothetical before, that's the conflicted piece. That's the piece that leads to the increase in compensation. So that's why so many more financial professionals are essentially covered by this activity, is because of this reinterpretation of the regular basis prong of the DOL's 5-part test. This is something I really want to get through on because I don't think enough people talk about this. It seems to be that it's black and white. It's either education or it's advice, and that's true to a degree, but there are different flavors, different use cases for education. So all of these things are not investment advice and therefore would not trigger a prohibited transaction or need for the exemption. One, you can market your services. If you market your services and you don't get into specific investment products or even strategies for a particular individual based upon his or her needs, then that's not investment advice. And I think we're well served to recognize that and account for it. You also might have pre-existing clients who just they have such a high degree of familiarity with you and satisfaction with what the services they're receiving that they don't ask you for your opinion. They leave their employer, they go to a new employer, they say, hey, can you give me the paperwork to fill out to get that 401k rolled over to an IRA that you can advise or manage like the rest of my accounts. And so we call that order taker, and there's special potential policies you could have around those occurrences. And then education, what the catch-all here is what it sounds like. It's very generic. Be careful that it's not just one communication the DOL is going to look at, it's all of your communications in the aggregate. And I would add the SEC is looking at all of this too, whether you're a broker-dealer and subject to Reg BI, or you're an investment advisor subject to the interpretation of the Advisors Act standard. They're really looking at rollovers as a sort of a high priority enforcement issue. These are the conditions. If you are the investment advice provider and you don't own the firm or otherwise have a home office role in compliance, legal supervision, et cetera, then a lot of this doesn't necessarily apply to you directly. But the firm has to be able to show it's complying with the impartial conduct standards, it's issuing written disclosures, including a fiduciary acknowledgement, description of services, conflicts, and for rollovers, you have to document the actual specific reasons why you recommended the rollover. There's compliance procedures that have to be in place sort of behind the scenes that doesn't incent advisors to recommend something that's not in the client's best interest. The firm has to do a retrospective review. We're starting to get a lot of calls on that. The software John mentioned really facilitates that on kind of more of an ongoing basis. But even there, we're getting calls from licensees of that decision optimizer tool. And how do we package up the data that we're getting from those transactions in a way that's going to be acceptable to the DOL in the format of a retrospective review? And then self-correction are things that need to be addressed proactively. You need to have a plan in place to how you're going to handle self-corrections before you find self-corrections. These are the big rocks from a rollover from a plan to an IRA perspective. You have to consider the investments, the services, and the fees. You also have to look at the ability for that participant to select different investment options. Whatever they're currently invested in isn't the end all be all. There's likely more funds available, more investments available on the current plan, and you have to be objective about their options. And notice this all says consider and document. When it comes to IRA and commission to fee, the only thing that the DOL expressly requires you to consider and document are the services. Now it goes on to say, we'll see here in the next slide, that you should consider the long-term impact of any increased costs and the reasons why the added benefits justify those costs, blah, blah, blah. But it's important to notice the DOL doesn't haphazardly choose its words. These are very carefully considered and reviewed words. And so I think we can take them at their word and treat these two different types of transactions differently from a compliance and documentation and expectations perspective. The SEC says in Reg BI, and it reiterated its intention that advisors should also be complying with this back in March of this year. End of March, they issued a staff bulletin saying, yes, investment advisors, even though Reg BI doesn't directly apply to you, this is something you should have been doing all along, is doing the comparison that we just saw, but also factoring in these additional considerations to the extent they're relevant to the client. So in our paper forms, for example, advisors have the ability to check the box not applicable if the client certifies that those are not applicable, and you don't need to get into these. In the software, the same thing, but you at least have to ask according to the SEC, because if the client says, yeah, actually the ability to delay RMDs is important to me, then you need to factor that into your analysis. So action items, and then we'll take a few questions. Again, I just wanted to get all of this to you. You'll have the deck from which to dig a little deeper and follow up with any questions afterwards. But for firms, you've got to train your stakeholders. Notice I didn't just say supervisors. It's all of the stakeholders on the requirements, and then new developments and interpretations that are absolutely going to follow this. We've already had one set of FAQs. We expect another relating to self-corrections and or retrospective review. The DOL is even suggesting it might change this exemption in the near term. So you've got to have a process to stay up on all of those changes. Determine whether you're going to allow reliable benchmarks. That's another thing that we really liked about the Broadridge solution, is they import very robust benchmarking capability into that tool. We have other firms using different benchmarking methods, but the DOL does allow you to fall back on benchmarks where the investor is unwilling or unable to get the actual plan information to you. Make sure you designate a responsible person who is the person preparing the retrospective review, because they'll need to weigh in on the strategy, and periodically sample documentation and rationale. So it's more looked at as like a rolling audit, so that you're not having to test everything at the end of your cycle. And then within 6 months, you're going to be required to certify, the senior executive officer certifies that report. It's much better to do it throughout the year, because then if you find cracks in the program, you can self-correct those before they get costly, even from a disgorgement, but particularly in in a rising market could become costly from a losses perspective, or I guess rising or falling market. So, and then confirm resources necessary to stay abreast. This is part of what the SEO, the senior executive officer, is certifying when they sign that retrospective review. So we packed a lot into 31 minutes, and we do have time to take a few questions. And then we're going to have the EPIC folks come back on, and maybe John Faustino to close this down. Oh, somebody was asking about that quadrant, and can I point my mouse to the quadrants I was speaking to, because there was some kind of a delay in the connection. I'll go back to that slide. I want to answer the next question before I do that. If we manage/charge a fee on a traditional IRA and recommend a Roth conversion to a Roth, will we also manage to charge the same fee? It sounds like this doesn't apply. And the question, I would agree, it shouldn't apply. The question you have to ask is, in that recommendation, is there any ability to affect your compensation? So let's say it was a different scenario where you're recommending a change in investment strategy, and you're going to charge X basis points for a more passive, maybe non-discretionary service, but you're going to charge X plus 15 for something that's more tactical and discretionary and so forth. That recommendation is increasing your comp. A recommendation to convert to a Roth is it's generally paid for with after-tax dollars. But to the extent that we're paying it for whatever reason out of the account, it's actually lowering your asset-based fee. So generally speaking, that's not going to be a covered transaction. Another person is asking about the expanding on the retrospective review. What is expected by the RIA firm regarding that component? It's a very, I don't want to say very detailed, but it is regimented. So the DOL outlines how it has to happen and what has to happen, and it's probably beyond what we can get into just in the few minutes we have left. But that's something, if you want to shoot me an email, I can follow up with you individually on. It's something that you have to test your compliance program to make sure that it is facilitating best interest advice, that you don't have violations with the conditions. To the extent you have any self-corrections, that those have been transmitted to the DOL as required by the self-correction requirements, and that they're included in their report. The SEO, when he's signing it, he or she's signing the report, they're certifying, among other things, that they have a process in place to stay abreast of changes in legislation, regulation, etc. A couple more, and then I'm going to turn it back over to I think John to close out. Can benchmarking be used for fee comparison? It is very difficult to adequately compare a rollover to an existing plan due to the multitude of hidden fees in plans. The short answer is yes, but the better answer is the DOL requires you to use prudent and diligent efforts to obtain the actual information. And if you're able to get a copy of the last statement, which all retirement investors should be able to access their own statements, and you have the annual fee disclosure, then the two of those should give you sufficient information to perform the analysis. If something is not shown on there, then the DOL can expect you to ferret it out. But with those two pieces of information, if we had more time on, I would kind of walk you through that process. You should be able to glean the information the DOL wants. Think about it too. It's also DOL where it's all about process. If you, in good faith, went through the process and you were off by a couple of basis points because something wasn't disclosed adequately to you, then the DOL is likely not going to, accuse you of making false and misleading statements and violating the impartial conduct standards, and you have to unwind all your transaction. It really is. It's about following the process and trying to comply with the conditions of the exemption. If you are unable to, after those prudent and diligent efforts, actually get that information, then they do give you a clear mechanism by which to use reliable benchmarks. So they kind of say publicly available data like the 5500 in the same breath as reliable benchmarks. I would submit for the 85% of the plans in the country that are less than 2 million in assets, the benchmarks are more reliable. Both, a lot of benchmarks are going to be more reliable than the 5500. So, but yeah, there is a process and some attestations that should go along with that decision. Last question: how will this language? How will this impact the large providers that run the 401k and then harvest the rollovers if it changes the share class for the investments and increases fees? Those providers, they have access to high quality counsel. They will figure it out. Under the conflicts of interest regulation, we saw a number of those large service providers embrace fiduciary standard of care because they had no choice. They would have to shut down that model or just call it what it is, where they were making recommendations. Right now, I think they can still, and particularly on a scripted, surveilled call center, you can still stay within the confines of education. Probably more so than a live human sitting in front of his or her client or prospective client would be able to stick to a script. So in that sense, they may have sort of a leg up in the ability to not have to comply with this because the door is still open to provide investment education and quote unquote harvest that opportunity. Okay, I think I'm sufficiently over, so I'm going to turn it back to our host and sponsor and let them close this out.
Well, thanks, Jason, John, and our partners at Broadridge, and thank you all for joining us on this Epic Insight webinar. As a reminder, we'll be sending out a copy of today's slides and a recording of the session as a follow-up. We wish you safety and health as you support your family, colleagues, and clients, and please don't hesitate to contact us if there's anything that Epic RPS can do to support you. Thank you.
Thank you.